The lawyer told me my legal strategy was fundamentally flawed and showed I'd never read the precedent case. I was the judge who wrote that decision. Attorney David Garrison leaned back in his leather chair and tapped his pen against the case file with my name on it. Mr. Reynolds, I appreciate that you think you understand contract law, but the precedent in Whitfield versus Consolidated Industries is crystal clear. Your employment contract with Meridian Tech includes a non-compete clause that's fully enforceable under current case law. Trying to fight it would be a waste of your money and my time. He said this with the kind of patronizing confidence that comes from never being seriously challenged. I sat across from him in his downtown office, my hands folded on my lap, watching him misrepresent my own judicial decision with absolute certainty. The Whitfield case had been one of my last rulings before I retired from the bench 8 months ago. I'd spent 3 weeks writing that opinion, carefully parsing the boundaries of enforceable non-compete agreements in Virginia. Garrison had either never actually read the full decision or had fundamentally misunderstood its central holding. I'd come to him through a referral from my former colleague, Judge Helena Voss, who'd retired 2 years before me and said Garrison was competent and discreet. I needed discretion because Meridian Tech was suing me for breach of contract after I'd started consulting for a company they considered a competitor. The CEO was the son of a state senator, and the case was getting media attention I didn't want. I'd hoped to resolve this quietly without revealing my judicial background, which would have made the whole situation a circus. Garrison pulled out a highlighted copy of what appeared to be a summary of the Whitfield decision, not the actual 43-page opinion I'd written. See here, the court ruled that non-compete clauses are presumptively valid and enforceable when they're reasonable in scope and duration. Your contract specifies 2 years and restricts you from working in medical technology, which is exactly what you're doing with BioAdvanced Solutions. Whitfield says that's enforceable. We should negotiate a settlement where you agree to stop consulting, and maybe Meridian drops the damages claim. I looked at the summary he was reading from and recognized it immediately. It was from a legal database that provided shortened versions of cases for quick reference, but it had left out the most critical part of my holding. The actual Whitfield decision had established a 3-part test for non-compete enforceability, and the third prong specifically addressed contracts signed under economic duress. In my opinion, I'd written that non-compete clauses agreed to as a condition of continued employment, rather than initial hiring, required heightened scrutiny because the employee lacked meaningful bargaining power. Meridian had made me sign their non-compete 6 months after I joined the company, threatening termination if I refused. Under my own precedent, that clause was almost certainly unenforceable. Garrison had missed this entirely. "Have you read the full Whitfield opinion?" I asked, keeping my tone neutral and curious rather than confrontational. Garrison waved his hand dismissively. "I've read the summary and the key holdings. That's standard practice. We don't have time to read every page of every case. The database summaries capture the essential points." I felt my jaw tighten, but kept my expression neutral. "The summary might be incomplete. The full opinion includes specific language about contracts signed post-employment under threat of termination. That's exactly my situation with Meridian." Garrison laughed, actually laughed, and shook his head. "Mr. Reynolds, I've been practicing employment law for 15 years. I know how to read case law. What you're describing isn't in Whitfield. You're confusing it with a different case, or maybe you read something on a blog that misrepresented the holding. This is why lay people shouldn't try to do legal research. You end up chasing theories that don't exist." His condescension was remarkable. I'd presided over complex litigation for 22 years, before retiring at 58 due to health concerns. I'd written over 300 published opinions, taught constitutional law as an adjunct professor, and served on the State Bar's Judicial Ethics Committee. And now, I was being lectured by a mid-tier employment attorney who couldn't be bothered to read a complete judicial opinion. I pulled out my phone and opened the legal database app I still maintained, found the full Whitfield decision, and scrolled to page 31 where I'd written the critical analysis. If you look at page 31, paragraphs 3 and 4, the court specifically addresses post-employment non-competes. I turned my phone toward him. Garrison barely glanced at it. "That's dicta, not holding. It doesn't create binding precedent. The central rule from Whitfield is that reasonable non-competes are enforceable. Period. Everything else is just the judge musing about hypothetical situations." I'd written that section carefully and deliberately, specifically intending it to be part of the holding, not dicta. I'd even cited it in 2 subsequent opinions to establish that it was binding precedent. But Garrison was so confident in his misreading that he wouldn't even consider the possibility he was wrong. The opinion cites to supporting precedent and applies the analysis to the facts. That makes it holding, not dicta, I said, my voice remaining calm despite the frustration building in my chest. Garrison closed the case file with a definitive snap. Mr. Reynolds, I need to be direct with you. If you're not willing to accept my legal advice, then perhaps you should find a different attorney. I can't represent a client who thinks he knows the law better than I do. My recommendation stands. We should settle this case, have you cease working with BioAdvance, and negotiate the damages down. Fighting this in court would be expensive and you'd lose because Whitfield supports Meridian's position. The ultimatum was clear. Accept his incompetent analysis or find someone else. The problem was that I'd already consulted with 3 other attorneys before Garrison, and they'd all given me similar advice based on the same superficial reading of Whitfield. The legal community had apparently decided what Whitfield meant without bothering to read what I'd actually written. This wasn't just about my case anymore. This was about attorneys across the state giving bad advice to clients because they were relying on incomplete summaries instead of reading actual judicial opinions. I stood up and gathered my documents. I appreciate your time, Mr. Garrison. I'll consider my options. Garrison stood as well and extended his hand for a shake that felt perfunctory. I hope you'll reconsider settling. Pride is expensive in litigation. Trust me on this. I left his office and sat in my car in the parking garage for 10 minutes, my hands gripping the steering wheel while I processed what had just happened. 4 different attorneys had all told me I'd lose a case that I knew I'd win based on precedent I'd personally created. The disconnect was staggering. I called Helena from the parking garage. She answered on the second ring with her characteristic warmth. Thomas, how did it go with Garrison? Is he taking the case? I told her everything, my words coming faster as the frustration spilled out. How Garrison had relied on a database summary instead of reading the full opinion. How he'd dismissed the critical holding as dicta. How he'd refused to even consider that his analysis might be flawed. Helena was quiet for a long moment after I finished. Thomas, you should have told him who you are. Shown him your judicial ID or something. Made him understand he was misreading your own decision. I'd considered that option before the meeting, but rejected it. I wanted to see if he could represent me on the merits without the complication of my background. Apparently that was naive. Helena sighed heavily. This is a problem we've talked about before. Too many attorneys don't read the full opinions. They rely on summaries and head notes and miss the nuance. You saw it from the bench, I saw it. But we couldn't do anything about it because we couldn't control how attorneys prepared their cases. She was right. I'd seen countless oral arguments where attorneys misunderstood the precedent they were citing, but my role as a judge was to decide the case, not to educate the attorneys on their own incompetence. Now I was on the other side of that dynamic, and it was infuriating. So what do? Represent myself and look like a fool? Find a 5th attorney and hope they actually read the case? Helena thought for a moment. Represent yourself. File a motion to dismiss based on the Whitfield precedent. Cite the specific pages and paragraphs. Make it so clear that the judge has no choice but to rule in your favor. Then the legal community will see that they've been misreading the case. The idea had appeal but also significant risks. Pro se litigants, even former judges, faced skepticism in court. Meridian's attorneys would use my lack of counsel as evidence that my case was weak. The media coverage would intensify if they discovered I was representing myself. But the alternative was accepting bad legal advice and letting Meridian destroy my consulting career based on a contract that shouldn't be enforceable. I told Helena I'd think about it and ended the call. That evening, I sat at my home office desk surrounded by printouts of my Whitfield opinion, my Meridian employment contract, and the complaint they'd filed against me. My wife Denise brought me coffee and stood in the doorway watching me work. You're going to represent yourself, aren't you? She'd been a paralegal for 20 years before we met and understood the legal system better than most attorneys. I nodded without looking up from the documents. Every lawyer I've talked to is giving me the same wrong advice. If I don't fight this correctly, I'll lose a case I should win, and thousands of other people will continue getting bad legal counsel based on a misreading of my opinion. Denise came into the room and sat in the chair across from my desk. You realize this will expose your background. The moment you file documents that cite Whitfield the way you're planning to, Meridian's attorneys will figure out you wrote the decision. Then the story becomes, former Judge sues company over non-compete he ruled on. That's front-page news. She wasn't wrong. The optics were problematic, but the alternative was worse. If I don't do this, I'm letting incompetence win. I'm letting Garrison and the others continue giving bad advice because they're too lazy to read complete opinions. Someone has to force the issue. Denise studied my face and then nodded slowly. Okay, but we do this right. You file a motion to dismiss that's airtight. You cite every relevant case, every supporting authority. You make it impossible for them to deny. I spent the next week drafting a motion to dismiss that was probably the best legal writing I'd done in my career. 28 pages, 67 footnotes, and citations to not just Whitfield, but the 7 subsequent cases where I or other judges had applied the post-employment non-compete analysis. I included the full text of the relevant passages from Whitfield so there could be no confusion about what the case actually said. I filed the motion on a Monday morning at the courthouse where I'd presided for over 2 decades. The clerk who processed my filing was someone I'd worked with for years, and her eyes went wide when she saw my name on the documents. Judge Reynolds, you're representing yourself? I smiled and said I'd retired, and this was just a personal matter. She processed the filing without further comment, but I could see her mind working, wondering what story she was now part of. Meridian's response came 3 weeks later, and it was exactly what I'd expected. Their attorney, a partner at one of the city's largest firms named Colin Westbrook, filed a 40-page opposition that doubled down on the database summary interpretation of Whitfield. He argued that my motion demonstrated a fundamental misunderstanding of controlling precedent, and that my interpretation of the post-employment non-compete analysis was creative but legally baseless. The irony was almost too perfect. Westbrook had included a footnote citing 3 other cases he claimed supported his reading of Whitfield. I recognized all 3 cases immediately because I'd written them, and in each one I'd explicitly applied the post-employment non-compete test to find the clauses unenforceable. I wrote a reply brief that was just 8 pages. I didn't need more than that. I simply quoted the relevant passages from the 3 cases Westbrook had cited, showing that they directly contradicted his position. Then I included a single footnote that said, "The court may find it relevant that this pro-SE litigant previously served as the circuit court judge who authored the Whitfield decision and all 3 supporting cases cited in defendant's opposition." I filed the reply on a Friday afternoon. By Monday morning, my phone was ringing with calls from reporters who'd gotten wind of the story. A legal blog had picked up the filing and written a piece titled, "Former Judge Battles Company Using His Own Precedent." The article included excerpts from my reply brief and Westbrook's opposition, noting the remarkable disconnect between what Whitfield actually said and what attorneys thought it said. The comments section was brutal. Half the commenters were lawyers defending Westbrook and arguing that I was trying to manipulate my own precedent for personal gain. The other half were pointing out that Westbrook had literally cited my own opinions against me without reading them. By Wednesday, the story had spread to the State Bar Association's newsletter and several legal podcasts. I started getting calls from former colleagues, some supportive and some concerned, that I was damaging the judiciary's reputation by involving myself in public litigation. Judge Marcus Green, who'd taken over my courtroom after my retirement, called me at home Thursday evening. "Thomas, what are you doing? This is making the court look bad. People are questioning whether your opinions can be trusted if even attorneys can't understand them." I'd expected this call, but it still stung. "Marcus, the problem isn't my opinions. The problem is attorneys who don't read them. If my motion forces the legal community to actually engage with the full text of judicial decisions instead of relying on summaries, that's a good thing for everyone." Marcus was unconvinced. "You should have settled this quietly. Now you've made yourself the story and dragged the court into a media circus." I told him I disagreed, and that I believed transparency in the legal system was more important than avoiding uncomfortable publicity. He hung up frustrated, and I added him to the list of professional relationships that were being damaged by this case. The hearing on my motion to dismiss was scheduled for early December, 3 months after I'd filed. Judge Andrea Kemp was assigned to the case. She'd been appointed to the bench 5 years ago and was known for being thorough and careful. I'd never worked directly with her, but knew she had a reputation for actually reading briefs instead of relying on oral arguments. That would help my case. The morning of the hearing, I arrived at the courthouse 30 minutes early. The gallery was packed with reporters, law students, and several attorneys who'd apparently come to watch the spectacle. I saw Garrison sitting in the back row, his expression unreadable. Westbrook arrived with 2 associates, all 3 of them carrying expensive leather briefcases and wearing suits that cost more than my monthly mortgage payment. Judge Kemp took the bench at exactly 9 a.m. and surveyed the crowded courtroom with mild surprise. "This is a motion to dismiss. I wasn't expecting an audience." A few people in the gallery laughed nervously. Kemp looked at me and then at Westbrook. "Before we begin oral arguments, I want to address the unusual nature of this case. Mr. Reynolds, you're appearing pro se despite being a retired circuit court judge. Mr. Westbrook, you're representing a defendant in a case where you cited the plaintiff's own judicial opinions against him without apparently realizing who wrote them. This situation is irregular, and I want to ensure we proceed appropriately." Westbrook stood immediately. "Your Honor, the defendant objects to any characterization that we didn't properly research the cited cases. We relied on controlling precedent as summarized in standard legal databases. The plaintiff's prior judicial service doesn't change the law." Kemp cut him off with a raised hand. "I've read the briefs, Mr. Westbrook. All 3 cases you cited in your opposition explicitly support Mr. Reynolds's position, not yours. I want to understand how that happened." Westbrook's face flushed red. "Your Honor, we interpreted those cases in the context of established legal principles. The summaries of those decisions supported our reading." Kemp pulled out a thick binder that I recognized as containing printed copies of all the cited cases. "Mr. Westbrook, did you read the full opinions of the cases you cited, or did you rely exclusively on database summaries?" The courtroom went completely silent. Every attorney present understood that Kemp was asking Westbrook to either admit he hadn't done basic research or to claim he'd read the cases and still gotten them wrong. Westbrook glanced at his associates, neither of whom met his eyes. "Your Honor, it's standard practice to use database summaries for initial research and to rely on the headnotes for the key holdings." Kemp leaned forward slightly. "That's not what I asked. Did you read the full opinions?" Westbrook's jaw tightened. "We reviewed the relevant portions as identified by the database." Kemp nodded slowly and made a note on her legal pad. "Mr. Reynolds, I've read your motion and your reply brief. I've also taken the time to read the full Whitfield opinion and the 3 supporting cases. Your analysis appears correct. The post-employment non-compete test established in Whitfield does apply to your situation, and under that test, the non-compete clause Meridian is trying to enforce appears unenforceable. Mr. Westbrook, does your client have any response to this that doesn't rely on incomplete case summaries?" Westbrook looked like he was struggling to breathe. He conferred with his associates in whispered tones for 30 seconds before turning back to the judge. "Your Honor, we request a continuance to fully research the issue and file a supplemental brief." Kemp shook her head. "Mr. Westbrook, you've had 3 months to research this issue. The motion to dismiss is granted. The non-compete clause is unenforceable under Whitfield, and the plaintiff is free to continue his consulting work. The defendant's complaint is dismissed with prejudice." The courtroom erupted in whispered conversations. Reporters were typing furiously on their phones. Westbrook looked stunned, his mouth opening and closing without words coming out. I stood and thanked Judge Kemp, then gathered my documents and walked out of the courtroom into the hallway where reporters immediately surrounded me. "Mr. Reynolds, how does it feel to win using your own legal precedent? Do you think this case proves that lawyers aren't reading judicial opinions? Will you file a malpractice claim against the attorneys who gave you bad advice?" I answered a few questions carefully, emphasizing that the case wasn't about embarrassing anyone, but about ensuring that legal precedent was properly understood and applied. I said I hoped the legal community would take this as a reminder to read full opinions rather than relying solely on summaries. One reporter asked if I planned to return to legal practice. I said no, I was happy in retirement, and this had been a unique situation. But even as I said it, I knew that wasn't entirely true. This case had reminded me why I'd loved being a judge: the intellectual challenge, the pursuit of justice, the ability to create clarity in complex situations. Retirement had felt necessary for my health, but watching Kemp apply my Whitfield precedent correctly had made me miss the bench more than I wanted to admit. The story dominated legal news for the next week. The State Bar Association announced they'd be conducting a study on attorney research practices and whether reliance on database summaries was creating systematic misunderstandings of case law. Several law schools added seminars on proper case reading and analysis. 2 legal database companies issued statements defending their summary services, while also encouraging attorneys to read full opinions for complex issues. Garrison called me 5 days after the hearing and left a voicemail apologizing for dismissing my analysis. He said he'd read the full Whitfield opinion after seeing the news coverage and realized he'd been giving bad advice to clients for years. He asked if I'd be willing to meet with him to discuss how he could improve his practice. I didn't return the call. Westbrook faced more serious consequences. His firm issued a public statement saying they were reviewing their research protocols and implementing mandatory training on case analysis. Westbrook himself was reportedly reassigned from complex litigation to document review. The firm's managing partner gave an interview to a legal publication saying they took the matter seriously and were committed to maintaining the highest standards. It was corporate speak for "we're humiliated and someone's getting punished." Meridian Tech dropped their damages claim and issued a statement saying they respected the court's decision and bore no ill will toward me. The CEO's father, the state senator, tried to use his influence to get the case reopened on appeal, but Meridian's attorneys apparently convinced him that would only make things worse. I received dozens of emails from people who'd been advised to settle non-compete cases they could have won. Former clients of various attorneys reaching out to share their stories of bad legal advice based on misread precedent. One email particularly stood out. It was from a woman named Leslie Thornton, who'd been sued by her former employer 3 years earlier over a non-compete clause nearly identical to mine. Her attorney had advised her to settle based on Whitfield precedent, and she'd paid $50,000 to her former employer and agreed to stop working in her field for 2 years. She'd lost her house, her savings, and her career momentum, all because her attorney had relied on the database summary instead of reading my full opinion. She asked if there was any way to reopen her case. I called Leslie that evening and explained that reopening a settled case would be extremely difficult, but I'd be willing to write a letter to the Bar Association explaining how the misreading of Whitfield had led to her bad advice. She cried on the phone and thanked me repeatedly, saying even if she couldn't get her money back, she wanted someone to acknowledge that she'd been wronged. I drafted the letter that night, documenting Leslie's case and identifying 6 other similar situations I'd learned about through emails and calls. I sent the letter to the State Bar's disciplinary committee and copied the Legal Aid Society and several consumer advocacy groups. The bar's response came 3 weeks later. They were opening an investigation into attorney research practices and would be reviewing cases where clients might have received bad advice based on incomplete case analysis. They asked if I'd be willing to serve as a consultant on the project. I agreed immediately. The consulting work led to something unexpected. The Bar Association asked me to teach a series of continuing legal education seminars on proper case reading and legal research. The first seminar had 120 attorneys registered, the maximum capacity. I stood in front of that room in January, looking at lawyers ranging from fresh graduates to senior partners, and talked about the Whitfield case. I explained what I'd actually written, how it had been misunderstood, and what the consequences had been for real people. I showed them Leslie Thornton's case and several others. I watched their faces shift from defensiveness to understanding to shame as they realized how many clients they might have failed. One attorney raised his hand during the Q&A session. "Judge Reynolds, how do we balance the need to read full opinions with the time pressures of modern practice? We have huge caseloads and clients who can't afford hundreds of hours of research." It was a fair question and one I'd anticipated. You don't need to read every case from start to finish, but when a case is central to your client's matter, when it's the controlling precedent that will determine the outcome, You have an ethical obligation to understand it completely. Database summaries are tools, not substitutes for analysis. If you're going to cite a case in a brief or rely on it for advice, read it. Not the summary, not the headnotes, the actual opinion. The seminar led to an ongoing relationship with the Bar Association. They asked me to review proposed changes to their ethics rules regarding attorney competence and research standards. I helped draft new continuing education requirements focused on legal analysis and case reading. By spring, I'd taught 6 more seminars and consulted on a dozen disciplinary cases involving attorney research failures. The work was satisfying in a way that retirement hadn't been. I was making a systemic difference, addressing problems I'd seen from the bench but hadn't been able to fix. Denise noticed the change in me immediately. I was energized, engaged, excited to work in a way I hadn't been in years. One evening in April, she found me in my office preparing materials for an upcoming seminar. "You're not retired anymore, are you?" She smiled when she said it, not accusatory but amused. I looked at the stacks of cases and research materials covering my desk and had to laugh. "I guess not. Is that a problem?" Denise sat down and took my hand. "The opposite. You've been happier these past few months than you were in the 2 years before you retired. This is what you were meant to do, teaching, improving the system, helping people get better representation." She was right. The Meridian case had started as a personal frustration, but had evolved into something larger and more meaningful. I'd found a way to continue serving the legal system without the health pressures of being on the bench. The Bar Association approached me about creating a permanent position as their Director of Legal Education and Ethics. The job would involve developing training programs, consulting on disciplinary matters, and serving as a resource for attorneys struggling with complex legal issues. I accepted without hesitation. Garrison reached out again in May, this time with a more substantive apology. He asked if he could take me to lunch to discuss what he'd learned from my case. I agreed, curious about whether he'd actually changed or just wanted to rehabilitate his reputation. We met at a quiet restaurant downtown. Garrison looked tired, his confidence from our first meeting completely gone. "I've spent 6 months retraining myself on legal research, reading full opinions instead of summaries, actually analyzing cases instead of just citing them. Do you know how many clients I gave bad advice to over the years?" I waited for him to answer his own question. "At least 30, probably more. I've been reaching out to former clients, offering to reopen settled cases if possible, refunding fees where I clearly failed them. My practice is basically on hold while I try to fix the damage I caused." I felt something unexpected, not satisfaction, but empathy. Garrison had been incompetent, but he hadn't been malicious. He'd been lazy and overconfident, problems that plagued the entire profession, not just him personally. "What do you want from me?" I asked, keeping my tone neutral. Garrison met my eyes. "I want to understand how to be better. You spent 22 years on the bench seeing attorneys at their best and worst. Help me be the attorney my clients deserve." We talked for 2 hours about legal practice, research methods, client communication, and ethical obligations. Garrison took notes on his phone and asked thoughtful questions. By the end of lunch, I'd agreed to meet with him monthly as an informal mentor. He wasn't a lost cause, just someone who'd never been properly trained and had learned bad habits from a profession that often rewarded efficiency over thoroughness. The monthly meetings with Garrison became part of a larger mentoring program I developed through the Bar Association. We created a system matching experienced attorneys and retired judges with newer lawyers who wanted to improve their practice skills. The program launched in August with 50 mentor-mentee pairs. Within 6 months, we had a waiting list of 200 attorneys requesting mentors. The legal community was slowly acknowledging that something had gone wrong with how lawyers were trained and supervised, and people wanted to fix it. My work also caught the attention of law schools. 3 different schools invited me to teach as a visiting professor, focusing on legal writing and case analysis. I accepted a position teaching 1 seminar per semester at the state's flagship law school. My first class had 60 students, and I started the semester the same way I'd started my Bar Association seminar. I told them about the Whitfield case, about how attorneys had misread my opinion for years, about real people who'd suffered because lawyers didn't do their jobs properly. One student raised her hand on the first day. "Professor Reynolds, if database summaries are so unreliable, Why do law schools teach us to use them? It was a cutting question, and completely fair. Because legal education has failed to keep pace with how technology has changed legal research. When I was in law school, we had to read cases in physical books. There was no shortcut. Now, you can search databases and get instant answers, but those answers are only as good as the algorithms and human editors who create them. The technology is a tool. The problem is, we've started treating it as a replacement for critical thinking. I restructured the entire course around that principle. Students had to read full cases, analyze them without relying on headnotes or summaries, and then compare their analysis to what the legal databases said about those cases. The exercises revealed how often the summaries were incomplete, misleading, or simply wrong. My students started posting their findings on social media, creating viral threads about the disconnect between what cases actually said and what legal databases claimed they said. The database companies were not pleased. 2 of them sent cease and desist letters claiming my course was defaming their products. I forwarded the letters to the university's general counsel with a note saying I welcomed the opportunity to demonstrate in court how inaccurate their summaries were. The letters stopped, but the companies did start revising their editorial standards and adding disclaimers encouraging users to read full opinions. By the end of my first year teaching, the legal landscape had shifted noticeably. More attorneys were reading full opinions. Bar associations in 4 other states had adopted research standards based on the model we'd developed. Law schools were revising their curricula to emphasize case reading over database searching. None of it would have happened if Garrison hadn't dismissed my analysis and forced me to fight back. The Meridian case had been personal at first, but it had exposed a systemic problem that the profession finally couldn't ignore. I ran into Westbrook at a bar association conference in December, almost exactly 1 year after Judge Kemp had granted my motion to dismiss. He approached me hesitantly during a break between sessions. "Mr. Reynolds, I owe you an apology. What happened in your case was inexcusable. I'd been practicing law for 20 years and thought I knew what I was doing. You showed me I'd been doing it wrong the whole time." I shook his hand and told him I appreciated the apology. Westbrook explained that he'd spent the past year retraining, much like Garrison had. He'd read hundreds of full opinions, rebuilt his research methods, and started supervising his firm's junior associates more carefully to prevent them from developing the same bad habits he'd had. "I'm actually teaching a session later today on research failures and how to avoid them. Would you be willing to sit in and give feedback?" I attended Westbrook's session and was impressed by his candor. He walked through the Meridian case in detail, showing the audience exactly where he'd gone wrong and what he'd learned. He didn't try to minimize his failures or blame the legal databases. He took full responsibility and used his humiliation as a teaching tool. After the session, several attorneys approached him to share their own stories of research mistakes. The vulnerability he'd shown had given others permission to acknowledge their own failures. The legal profession was slowly becoming more honest about its weaknesses. That evening, the Bar Association held an awards dinner recognizing attorneys and judges who'd made significant contributions to the profession. I attended mostly out of obligation, expecting a boring evening of speeches and rubber chicken. Then, the Bar Association president announced a special award. "This year, we're recognizing someone who forced our profession to confront uncomfortable truths about how we practice law, someone who turned a personal legal dispute into a catalyst for systemic change. Please join me in honoring retired Judge Thomas Reynolds with our Distinguished Service Award." I was genuinely surprised. I walked to the podium while the room applauded, and I accepted the award from the president. When the applause died down, I spoke briefly about what the past year had taught me. I didn't set out to change anything. I just wanted to resolve my own case. But sometimes personal problems reveal systemic failures, and when they do, we have a responsibility to address them. The legal profession exists to serve clients and ensure justice. When we cut corners, when we rely on summaries instead of analysis, when we let efficiency override thoroughness, we fail that responsibility. Thank you for acknowledging that failure and working to fix it. The speech received a standing ovation, which felt both gratifying and strange. I'd spent my career on the bench avoiding publicity and personal recognition. Now I was being celebrated for embarrassing the profession I'd served. But maybe that's what the legal system needed. Not judges who stayed quietly above the fray, but practitioners willing to call out failures even when it was uncomfortable. I thought about Leslie Thornton and the 30 clients Garrison had failed, and countless others who'd received bad legal advice based on misread precedent. The award wasn't really for me. It was acknowledgement that the profession needed to do better, and that change requires people willing to fight for it even when the odds seem impossible. A year and a half after Judge Kemp granted my motion to dismiss, I was teaching full-time, consulting with the Bar Association, mentoring dozens of attorneys, and serving on 3 state committees focused on legal education and ethics reform. Denise joked that I was busier in retirement than I'd been on the bench. She was right, but this work felt more impactful. As a judge, I'd decided individual cases. Now I was helping to shape how an entire profession approached its work. My daughter called one evening to tell me she'd decided to go to law school. She'd been working in healthcare administration, but said watching how I'd fought Meridian Tech had inspired her to pursue a legal career. I want to be the kind of lawyer who actually helps people, who reads the cases and does the work right. You showed me that's possible. I told her I was proud of her and that the profession needed more lawyers who cared about getting it right. A week later, I received an email from a law student at a school in California. He'd read about my case in his legal writing course and wanted to know if I'd be willing to speak to his class via video conference about the importance of thorough legal research. I agreed, and that video conference led to invitations from 5 other law schools. By the second year after the Meridian case, I was consulting nationally on legal education and research standards. The American Bar Association asked me to chair a commission examining attorney competence and technology's impact on legal practice. The work was overwhelming but necessary. The commission's report, published 18 months later, made 50 recommendations for improving how lawyers are trained, supervised, and held accountable. Several recommendations became model rules adopted by state bars across the country. The legal community had transformed from defending its practices to genuinely examining how to improve them. Not every attorney embraced the changes. Some older practitioners resented the implication that they'd been doing things wrong. Some complained that reading full opinions was inefficient and clients couldn't afford the extra time. But younger attorneys and law students overwhelmingly supported the reforms. They wanted to practice law the right way and appreciated having clear standards to follow. I kept teaching my seminar at the law school, watching new generations of lawyers learn to read cases carefully and critically. Several of my former students reached out after graduating to tell me the skills I'd taught them had made them better advocates and saved their clients from bad outcomes. One student sent me a case file where she'd caught an opposing attorney misrepresenting precedent, much like Westbrook had done in my case. She'd written a brief citing the full opinions and won her motion. "You taught me to never trust a summary," she wrote. "Thank you for that." 3 years after winning my case against Meridian, I was invited to speak at the State Judicial Conference, an annual gathering of all the judges in Virginia. I stood before my former colleagues and talked about what I'd learned from being on the other side of the bench. I talked about how attorneys were failing clients through incompetence rather than malice, about how the legal system's complexity had become an excuse for not doing basic work, and about how judges needed to hold attorneys accountable for misreading precedent. Some judges in the audience looked uncomfortable, but most were nodding in agreement. Several approached me afterward to say they'd seen the same problems from the bench and were grateful someone was finally addressing them publicly. Judge Kemp, who'd presided over my case, pulled me aside after the speech. "You've done more to improve legal practice in 3 years than most of us accomplish in an entire career on the bench. I'm glad I could play a small role in starting this by ruling correctly on your motion." I thanked her and said her willingness to actually read the cases had made all the difference. If she'd relied on the same summaries Westbrook had used, I would have lost despite being right on the law. She promised to continue holding attorneys to high standards in her courtroom. The work continues. I still teach, still consult, still mentor attorneys trying to improve their practice. The legal profession is better than it was 4 years ago when I sat in Garrison's office and heard him confidently misrepresent my own judicial opinion. But there's more to do. The problems I exposed weren't unique to Virginia or to employment law. They exist everywhere in the legal system, waiting for someone to care enough to fight back. I'm grateful that my personal frustration became a catalyst for change, and I'm committed to continuing this work for as long as I can. The Meridian case taught me that retirement doesn't mean you stop serving justice. It just means you find new ways to do it. Thanks for watching till the end. Make sure to subscribe and like to not miss the next story.